Okay, we are live.
Good afternoon and welcome to the House Environment Committee. This afternoon, we are going to continue our conversations about clean water with Scott Sanderson from Conservation Law Foundation. Welcome.
Thank you very much, Chair Sheldon, members of the committee. Thank you so much for having me here to chat a little bit about the Clean Water Act and agriculture in Vermont today. My name is Scott Sanderson. I'm an attorney at Conservation Law Foundation. I also direct our regional farm and food program, which includes the Legal Food Hub, which is a free service for income eligible farmers and food professionals that gets them free legal assistance. I've been asked to talk a little bit about recent EPA letter to ANR that EPA sent to inform ANR that the way that Vermont regulates agricultural water quality does not meet the minimum requirements of the Clean Water Act. So what I'm going to do throughout this presentation is try to put that letter into context. So talk about how we got there, talk a little bit about the letter itself, and then where things are going from here. And so along the way, I want to chat a little bit about some key concepts in the Clean Water Act. A lot of these will be familiar, but I want to put them into an agricultural context. Talk about delegation and redelegation, which is the process that's by which EPA gives states authority to administer the Clean Water Act within a state and can take it away. Go over how agricultural water quality is regulated in Vermont, and then get into the weeds on the dedelegation petition that gave rise to EPA's letter, and then leave time for questions. So there's a lot there. Along the way, please feel free to ask questions. I'm happy to answer along the way. Cool. So let's start with some key concepts on the Clean Water Act. So what does the Clean Water Act do? In the context of agriculture, the Clean Water Act prohibits farms from adding pollutants like pesticides or nutrients, manure, to jurisdictional waters like Lake Champlain or Lake Memphremagog from a point source without a NPDES permit. And so two key concepts here are point source and NPDES permit. And we'll start with point source. The Clean Water Act regulates point sources, but does not regulate other things. So point sources are essentially concentrated sources of pollution that pose a risk to water quality. And so the prototypical point source is something like a pipe that emerges from a factory and that discharges pollution into a water body. It's also important to note that some farms are point sources, and those are called concentrated animal feeding operations. So given this definition, there are a lot of point sources on farms. They include things like drainage ditches, manure lagoons, silage bunkers, manure spreaders, and pesticide sprayers. And because concentrated animal feeding operations are point sources, it means that sometimes discharges from fields and overland runoff can be considered point source discharges that the Clean Water Act regulates. Okay, so I bolded concentrated animal feeding operation because that's another important concept here. So what is a CAFO? Concentrated animal feeding operation is a farm with livestock that the Clean Water Act regulates as a point source because it presents a greater risk to water quality than other farms do. So not all farms are CAFOs, but CAFOs are the farms that the Clean Water Act most directly regulates as point sources. So in Clean Water Act terms, a CAFO is equivalent to a pipe that comes out of a factory, right? It's treated as a unit that is regulated. And now to put that risk to water quality into context, I wanted to find some way of comparing them. So I compared Vermont's largest CAFO to Burlington in the context of phosphorus pollution. So in Vermont, we're often very concerned about phosphorus pollution because it poses a risk to water quality in water bodies like Lake Champlain, where it creates toxic algal blooms. The manure stream that is created by Vermont's largest CAFO contains 4 times as much phosphorus as the sewage stream that comes out of Burlington. And so there's a significant amount of potential pollution that CAFOs have to manage, and that can pose a challenge. And so that's why the Clean Water Act treats CAFOs as point sources. So then you have to know how to identify a CAFO, right? And so CAFOs are identified by their type, their size, and their impact. So only farms that raise and confine livestock can be CAFOs. So a dairy farm can be a CAFO, but an apple orchard can't be. Size matters. So the larger the farm is, the more likely it is to be a CAFO. So some farms, just by virtue of their size, are CAFOs. And impact also matters. So farms that may not meet a particular size threshold may be designated as CAFOs because they have been identified as posing a unique risk to water quality because of the facts of because of their circumstances. And so to make this just a little bit more concrete, every large farm operation in Vermont is a large CAFO because of its size, right? All large CAFOs in Vermont have to have more than 699 cows, and that makes it a concentrated animal feeding operation. So just to underscore this, a CAFO is a point source, including its fields. And so everything that you see inside the circle here is part of a larger point source. Yeah. Oh, sorry.
Representative Logan, although I am going to ask folks to be judicious in their questions today and let the presentations play out, because often questions get answered later, but let's try yours.
Okay, thanks. So a large farm operation is a large farm operation based on head of cattle, irrespective of management practices.
Exactly. So the one management practice that would matter is whether or not the farm stables or confines its animals for a certain period of time. And since we're in Vermont, where we have winter, and you're going to have to bring your cows into the barn over the winter, that practice is, or that criteria is essentially always met. So you really only need to look at animal numbers. Yeah. Okay, so I'm going to add a wrinkle to this, and that is nutrient management plans. So nutrient management plans are tools under the Clean Water Act, and they're essentially plans that farms use to apply manure and fertilizer at the appropriate rate, time, and place to support healthy crops and to protect water quality. So if you're a farm and you have a properly developed nutrient management plan based on current soil tests and accurate figures about your manure, those sorts of things, and you follow that nutrient management plan, and then you have runoff from your fields, which of course is very difficult to control overall, that would be non-point source pollution because you followed the nutrient management plan. If you have a flawed nutrient management plan or you don't follow it, for example, you applied too much manure or something like that, that would be point source pollution. So it gets a little bit complicated there, but I wanted to introduce this concept because EPA has a fair amount to say about it. And then the last thing, remember, Clean Water Act prohibits the discharge of pollutants without a permit. So the permit itself is an important thing. And a NPDES permit is a Clean Water Act permit that protects the permit holder from liability for discharges that comply with the permit. In the context of agriculture, these permits tend to have rigorous terms that protect water quality. They're issued via a public process that is meant to promote trust and transparency in public rights. And they protect permit holders from excess liability if the permit holder complies with the permit. So if you're a permit holder, if you're a farm with a NPDES permit and you have really bad luck, like a major storm that causes discharges, you're protected. Right now, under the current system, which relies on state permits, you aren't. Okay, so those are the key concepts. And now into delegation and de-delegation. So the Clean Water Act is EPA's statute, and it's a federal statute. And so the question is, how did Vermont come to be kind of involved in this? Basically, running the Clean Water Act is a really, really big job. And so the Clean Water Act authorizes EPA to delegate its authority to run the Clean Water Act to state agencies through a process called delegation. When EPA does that, it steps back into an oversight role, and its job is to make sure that states are running programs that at all times meet the minimum requirements of the Clean Water Act. And this is exactly what's happened in Vermont. EPA delegated authority back in 1974 to Vermont. Of course, in that oversight role, EPA's job is to make sure that things are going well. And if a state program is no longer complying with the Clean Water Act, EPA can take back its authority. And some reasons that it might do this: state might fail to issue required permits. There might be conflicts between state law or regulation and federal law or regulation. The state may fail to inspect and monitor regulated entities, and the state might fail to enforce when violations occur. So when EPA looks at this, it's treating the Clean Water Act as a floor. So it might look at the totality of a state's program. So for example, stormwater might be going well, something to industrial regulation might be going well. But if any one of the programs under the Clean Water Act isn't going well, EPA is responsible for stepping in and working with the state to bring the program back up to minimum requirements. It's also worth noting that within these different program areas, independent state programs can't be used by the state to, I guess, cure deficiencies. So if you have problems in the core of the Clean Water Act, so for example, your NPDES program, your NPDES permitting, your enforcement, or your regulations, you may have other things going on in the state that are going really well. You might be providing excellent technical assistance, excellent grant programs, excellent education programs, things like that. But these green blocks can't get stacked up onto the red blocks over here to bring the program into compliance. You still have to address the particular challenges under the Clean Water Act. So usually EPA finds out about deficiencies in state programs through a petition process. So, and they're usually called dedelegation petitions. And those petitions are quite common. So I've just grabbed a thumbnail from EPA's website here on the right. And this is just the page where they list all of the pending petitions. And you'll see that many of these are pending. And the reason that they're pending is that EPA responds to these usually by investigating the allegations in the petition and making findings. And if it finds that there are deficiencies in the program, it works with the state to correct those deficiencies, including through legislation. And once the deficiencies are corrected, EPA will then dismiss the petition as if everything were fine from the beginning. So that's sort of how it treats it. EPA much prefers to work with states to resolve the challenges. That's its general approach. Okay, so that's delegation and de-delegation. And again, Vermont gained authority to regulate point source pollution on farms in 1974 when EPA delegated. Okay, so how does agricultural water quality regulation work in Vermont? Basically, Vermont's system relies on a split of jurisdiction between ANR and AAFM. So the first part of that split is point source pollution. The EPA delegated authority to ANR to regulate point source pollution under the Clean Water Act in 1974, and that's that big delegation. Then in 1991, and there have been many modifications since then, the legislature, through Act 261, directed ANR to delegate non-point source pollution regulation on farms to AAFM. So that leaves us in this situation where ANR is meant to regulate point source pollution under the Clean Water Act. It's supposed to issue NPDES permits to CAFOs. And then on the other side, AAFM is supposed to regulate non-point source pollution. Again, Clean Water Act is very focused on point source pollution rather than non-point source pollution. AAFM also runs a number of state regulatory programs, including the LFO, MFO, and CSFO programs, and they administer the required agricultural practices. It's really important to note that no farm in Vermont has ever held a NPDES permit. So we do have a medium farm general permit, but no farm is covered by it either. Now, this division of authority, what you can see is that the list here is quite a bit longer on AFM's side, and the number of programs that they're running are much more active than ANR's programs. As a result of this, AFM is conducting almost the vast majority of inspections on Vermont's farms, which means that close collaboration between the agencies is really, really important, right? Remember what EPA is looking for. They're looking for ANR to control and monitor for point source pollution on farms, but AFM is doing most of the looking. So the system is built on close collaboration, and you have to find a way to make that work. And what we have right now, ANR and AFM have entered into a memorandum of understanding, basically an agreement that when AFM conducts inspections, it will immediately notify ANR about potential point source discharges, and it'll document everything that's happened, send those documents over to ANR. ANR will investigate and determine whether or not there is a violation under the Clean Water Act, and then will take whatever enforcement action it considers necessary, including potentially requiring permits. Okay, so that's the overall framework that we're looking at. And so now we get into the dedelegation process and what's going on in Vermont with dedelegation. So dedelegation has a very long history in Vermont, and it started back in 2008 and 2013. Back then, the clinic at Vermont Law School and CLF submitted a different dedelegation petition to EPA that dealt with a lot of different challenges throughout Vermont's Clean Water Act program. EPA went through the normal process, right? They investigated those allegations and they did find deficiencies, and they required Vermont to make various fixes. And some of those fixes were legislative. In particular, I just want to highlight one finding that EPA found back in 2013. And that was that they found that Vermont's CAFO program was inadequate, right? So the way that Vermont was regulating agricultural water quality was inadequate. And here's that particular quote: ANR has never issued a NPDES permit, that's still true today, to any CAFO in Vermont, and has not adequately regulated a sector of dischargers that are subject to the NPDES program, right? So these challenges are pretty longstanding, and the EPA has notified the state about this sort of problem before. So in the wake of that petition, Vermont implemented a variety of reforms, including legislation. And about 9 years after that, CLF, BNRC, and LCC conducted a significant records review to see how things were going. And what we found was that there were continued challenges, particularly in the CAFO program, in the agricultural regulation program. And so based on that extensive records review, we filed a dedelegation petition that was focused on agricultural water quality regulation. This is that petition. This, I believe, is going to be on the committee's website. So I just wanted to make sure that there was a link so that you all can access the petition easily and review it if you want. Okay, so our petition documented how the collaboration between ANR and AAFM that is so critical to making agricultural regulation in Vermont work is not working. So what we found were critical disagreements between the two agencies, in particular disagreements about what a point source is. So very fundamental to the Clean Water Act. We found communications problems, including delayed referrals or non-referrals when AAFM found evidence of point source discharges. We found delayed reporting. So inspection reports took a very long time to be developed and sent over to ANR. Again, there were no NPDES permits at that time issued to CAFOs. That's still true. And then we found widespread problems with nutrient management planning. So again, that key document that is meant to help farms manage nutrients so that they don't damage water quality. So pretty extensive problems. And we also found that staff in the agencies recognized that there were major challenges. So these are quotes from relatively high-level folks in the agencies. So on the left is ANR. It seems pointless to discuss these details anymore when we are both working within such a confusing and highly flawed system. That's between ANR and AAFM talking. And then on the right, AAFM. On paper, every definition is clear. In the field, no definition is clear. So lots of challenges with communication between the agencies, lots of challenges determining who is supposed to be acting when because of that underlying split jurisdiction. Okay, so based on our petition, EPA conducted a 2-year independent investigation. And as you can imagine, EPA has tools that we don't have. They were, of course, able to look at all the same records we were able to look at, but they are also able to join inspections, conduct inspections of their own, right? They can do quite a bit more. And that culminated in the letter that I showed you right at the beginning of this presentation. And again, I've put this up here so that you all can review it when you have a chance. And so the main conclusion that EPA came to was that ANR's program operations, and what they mean by that, of course, is the CAFO program, the program that's regulating farms in Vermont, are clearly failing to meet the requirements of the Clean Water Act. And they focused on 4 primary failures. So the first is inadequate monitoring and enforcement. And what they said here was that ANR fails to conduct sufficient and timely inspections. and that they aren't enforcing in a way that will prevent violations from occurring. And they diagnosed this as being largely due to ANR's reliance on AAFM, and that the relationship there often breaks down. EPA also pointed to problems with regulations, basically places where Vermont regulations conflicted with federal regulations. They noted failure to require NPDES permits on CAFOs. So under the Clean Water Act, you have to have a permit at the time you discharge. Otherwise, you're violating the act. And what EPA found was that there was ample evidence in the record that farms are discharging pollutants, and those farms should have had NPDES permits, but didn't. So again, and then they pointed back to the 2008 petition, basically said, hey, Vermont has been aware of this, what's going on? And then just like we found, they noted that there was a failure to require proper manure management. So they noted that insufficient review and oversight of these nutrient management plans is resulting in farms applying manure at inappropriate application rates in fields that are unsuitable and in locations that are not sufficiently protective of water quality. And so those are the key pillars of the Clean Water Act when it comes to farms. Lots of problems there. And so this is basically the situation that EPA described, right? There are these key pillars of Clean Water Act regulation as it applies to farms, where Vermont is falling below the minimum requirements. And there are a lot of good things going on, right? There's really good technical assistance and grant support that AAFM is providing. But again, these fundamental commitments aren't being met. So EPA looked at those 4 failures, and then they tried to figure out, okay, well, what is causing this? And they concluded that there were 2 main causes to these problems. And the first was the division of authority between ANR and AAFM. And the second was that they felt that ANR does not have sufficient resources to administer a successful CAFO enforcement and permitting program. And I'm just noting here that these are things that are baked into Vermont law and that they would require a legislative fix. So EPA spent a lot of time dwelling on these points. So I just wanted to include a number of quotes here so that as you go back through, if you review the presentation later on, you can refer to these. I think one that essentially on this particular cause, dual authority and reliance on AFM undermine ANR's Clean Water Act program. The quote that I often come back to is this last one, that dual authority over the regulation of agricultural stormwater has existed in Vermont for decades now and has failed to ensure compliance with the CWA. So they were very focused on this division of authority and felt that it had a ripple effect that essentially undermined the entire program. So then on cause 2, they were also quite focused on that. Again, they felt that ANR did not have the staffing or the capacity that it needed to run a fully compliant program. My understanding is that I believe ANR has 2 staff in the CAFO program, and that's certainly not enough. So in response to this, EPA outlined 2 practical solutions, and for the first one, again, dual authority being the problem. Their solution, they said that the only viable option of those presented is consolidated agricultural authority with ANR. And they expanded on this to just explain that that means ANR has to be responsible for CAFO permitting, monitoring, enforcement, conducting routine inspections, right? It can't be relying on AAFM, enforcing nutrient management planning requirements, and administering just discharge purposes. So it's a pretty big change from this. That would be a pretty significant change from the status quo. And then cause 2, as you can imagine, if EPA is diagnosing not enough resources for ANR, their solution is provide enough resources so that ANR can conduct those key activities. Okay, so that all happened back in September. In December, ANR submitted a proposed corrective action plan to EPA, and essentially that plan did not incorporate EPA's solutions. So instead of consolidating authority within ANR, the plan slightly modified the status quo by adding initial joint inspections on large farm operations and medium farm operations. And those joint inspections would be intended to divide to help the agencies divide authority over individual farms between the two agencies. So not a significant change from how the system works right now. And then second, ANR did ask for, or did propose, a limited staffing increase, but it was based on ANR's proposal, right, which was much narrower than what EPA was asking for. So that proposal would not provide ANR sufficient staff to do what EPA is asking them to do. Okay, and so then we have a little bit of late breaking news. We learned over the last little while that EPA sent a letter to ANR responding to the draft correction plan on Friday. And EPA essentially reaffirmed a number of its concerns from its September letter. Again, it highlighted its concerns with the continued substantial role of AAFM in effectively administering the Clean Water Act on farms. And then it highlighted concerns with resources. I think one thing that's very important to note for this committee is that EPA also emphasized the important role that the legislature plays in this overall process, right? EPA said that it needs to see proposed legislation in order to complete its evaluation, right? A plan is not enough without actually seeing the implementing language that legislation and regulation would bring. And so here's just a quote that I pulled from that most recent letter, which should be which should be posted to the committee's website at some point. So because plan implementation will hinge on legislative action, EPA will need to comprehensively evaluate draft legislation and proposed implementing regulations related to the plan prior to approving it. And so all that is to say that the legislature has a major role to play here. This is not just between EPA and ANR. It also includes the legislature, since legislative action will be needed. And so that being the case, given where we are now, given that we need a legislative fix, and this is the position that Vermont finds itself in, how can Vermont reach the Clean Water Act floor? And I think from our perspective, the clearest path forward is to follow as closely as possible what EPA was directing in that initial letter. First off, to consolidate authority to regulate agricultural water quality within ANR. ANR is the agency that is charged with administering the Clean Water Act. They're the agency that is charged with protecting clean water. It makes sense for them to act in that regulatory role. AAFM came in last week and described a lot of excellent programs that they're working on. It's important to continue to empower AAFM to provide technical assistance, grants, and support to farmers. There's, EPA's letter notwithstanding, there's still an important role for AAFM to play in ensuring water quality. It's just that it's not the regulatory role under the Clean Water Act. That should be ANR's role. It would also make sense to follow EPA and provide ANR adequate staffing and resources to the Clean Water Act, right? They're in a position right now where they simply don't have the staff that they need to get the job done. And then last, I think it would also make sense for Vermont to shift from state LFO and MFO permits to Clean Water Act NPDES permits. And again, just going back to that initial slide on what NPDES permits are and the benefits they provide, those permits provide, they have strong terms that protect water quality. They provide a public process and public transparency that isn't available under the current system. And then for farmers, they protect farmers from excess liability when things go wrong. So for example, as we see climate change bringing more extreme weather, those protections will be more welcome. And the current system, the current LFO permits, the state law permits, doesn't provide that. Okay, so that's what I've got for you. But hopefully we got time for questions.
We definitely have time for some questions. Thank you for that.
Absolutely.
Is there a sense of how many staff would be enough at ANR to adequately meet the need?
I don't have a good sense for that. I'm sorry.
Questions, Representative
Will
Austin?
will the EPA provide funding to increase resources?
I also don't know the answer to that question. I suspect not, but I'm not sure.
What was the question? I didn't hear it.
Will the EPA provide funding to increase resources?
We'll have the ANR in soon with money. Yes, Representative Norris.
So what you mentioned, there'll be some liability protections under the NIPD's permits?
Yes, absolutely.
What does that entail?
So essentially, if you're a farm that has a NIPD's permit and you comply with its terms, you are insulated when things beyond your control go wrong. So imagine you have a big storm, a lot of precipitation. It causes some farm infrastructure to fail, but the way that you constructed that infrastructure met the permit terms. Even if pollution from that infrastructure reaches a surface water, your permit would protect you from liability. So you wouldn't have violated the Clean Water Act. Under the current system with the current permits, that's not the case. Those permits don't provide that protection.
Representative Austin.
I'm assuming there are huge farms across the United States,
Mhm.
much bigger than Vermont. Are these regulations apply to those farms as well, or are they under a different system? Because I'm wondering, has anybody figured out how to, have a non-point source of, I think that's right, what I'm saying, of manure near water or not polluting fresh water? Are there technologies or, ways of doing it so that you don't have to worry about, polluting the water?
Yeah, so there are certainly ways to protect the water. I think on the regulatory system side of things, a lot of states are in similar positions to Vermont, where there are problems with how the regulatory system is working, where farms that need to be regulated aren't being regulated. And so, these sorts of discussions are live in many places. But different states do better on Clean Water Act metrics than others. So for example, a lot of states issue permits to essentially all of their CAFOs. And I guess a good example of that would be Pennsylvania, which has a similar structure to its agricultural economy as Vermont. And they essentially require all farms that meet certain size thresholds to get Clean Water Act permits and to comply with those terms. But yes, the way that different states do this is different. What I would say is that what another state does is not I don't think I would interpret it as a standard. So if Vermont were to simply copy, for example, Maine or Michigan or Wisconsin, that doesn't necessarily mean that the program will work in Vermont, right? EPA is most concerned with results and making sure that the program is meeting minimum requirements. And what that entails will vary by state because different states are going to face different challenges, whether those are challenges in the field or even challenges with how government programs are structured. And so, one state is doing it can be a useful example, but it doesn't necessarily guarantee success and it doesn't necessarily guarantee approval.
Thank you.
Further questions? All right, thank you for your testimony.
Absolutely.
All right, members, we have our next agenda witness is at 2, so we have a little time for a break. So we will go offline.